Stop scrolling for a second. If you have a 2-year conditional green card in your wallet right now, you need to listen very carefully, because one small mistake in the next few months can quietly destroy your entire immigration future. I'm not talking about fake marriages or obvious fraud. I'm talking about real couples, real families, real people who love each other and built a life together, but still lost their status because they trusted the wrong advice, filed the wrong form, or assumed USCIS would understand their situation. USCIS does not assume. USCIS does not give second chances easily. And once an I-751 is denied and your conditional status is terminated, there is no reset button. You don't just try again with a new form. Very often, your case is handed over to immigration court. So stay with me. In this video on Immigration Bulletin Hub, I'm going to walk you through how the I-751 removal of conditions process really works, how officers actually think when they review your file, the specific traps that cause good faith couples to lose, and what you can do right now to protect yourself before it's too late. If you're watching this, there's a high chance that you or your spouse has a 2-year conditional green card, or you're getting close to the time when you'll have to file Form I-751. From the very start, we need to destroy one dangerous misunderstanding. This is not a simple renewal. It is not an automatic extension. It is not just another form to send in. The removal of conditions process exists for one central reason: to detect and stop marriage fraud. That's how Congress designed it, and that's how USCIS is trained to see it. Officers do not start from, "This couple is probably fine." They start from, "This category is high risk," and you have to convince them with evidence. Remember how you got the conditional green card in the first place. At the time your marriage-based green card was approved, your marriage was less than 2 years old. Under the law, marriages under 2 years are automatically treated as higher risk for fraud. It doesn't matter that your relationship is genuine. It doesn't matter how you feel about each other. It doesn't matter how long you dated before marriage. The law looks at one thing: the date you got married and the date your green card was approved. Less than 2 years between them means conditional status. That 2-year card is not sounds a sign that USCIS almost trusts you. It's a test. It's the government saying, "We see this as a risk category, and in 2 years you're going to have to come back and show us that this marriage was and still is real." That second test is Form I-751, Petition to Remove Conditions on Residence. This is where some of the most damaging, completely avoidable mistakes happen. And they happen a lot more often than people think. One of the worst mistakes is filing the wrong form. Many conditional residents file Form I-90 because they assume they're just renewing an expiring green card like everyone else. That is wrong, and it can be catastrophic. Form I-90 is used by people who already have a 10-year permanent green card. It's for replacing a lost card, fixing a printing error, or renewing a 10-year card that's about to expire. If you are a conditional resident and you file I-90 instead of I-751, you're essentially telling USCIS that you don't understand your own status. They will not fix it for you. They will deny the I-90, and if you fail to file I-751 in time, they can terminate your conditional residence. Some people have ended up in removal proceedings just because they chose the wrong form. So let's be absolutely clear. If your card is valid for 2 years and says CR1, CR6, CF1, IR1 with conditions, or similar, the only form that protects you is Form I-751. Now let's talk about what USCIS is actually looking for when they review that form, because this is where good people get blindsided. USCIS is not impressed by emotion. They're not moved by long love letters, romantic stories, or how sincere and nervous you sound at the interview. Officers are trained to set aside emotional narratives and focus on objective evidence. Their central question is always the same: was this marriage entered into in good faith, or was it entered into for immigration purposes? To answer that, they look for patterns that show two people truly living a married life over time. They want to see shared responsibility, shared decisions, shared risk, and shared day-to-day existence. One of the first things they examine is whether you actually live together. Not sometimes, not on weekends, not on paper. They want to see that your real lived-in address is the same. Leases or mortgage statements with both names are powerful. Utility bills, official mail, government notices, bank and credit card statements, driver's licenses, anything that shows both spouses connected to the same address tells USCIS these two people really share a home. If you lived apart at any time during the 2-year conditional period for work, school, military service, family obligations, or medical reasons, you must clearly explain that and back it up with evidence. Separate addresses with no explanation create suspicion. Gaps in your co-residence history are exactly the kind of thing that make an officer wonder whether the marriage is truly ongoing. Finances are another major area of scrutiny. Real married life usually involves some level of financial integration. USCIS knows that not every couple merges everything, but they expect a reasonable degree of shared financial life. Joint tax returns, or IRS transcripts, filed as married filing jointly, are among the strongest pieces of evidence you can submit. They show that, in the eyes of another government agency, you are presenting yourself as a real married couple. Joint bank accounts used for actual daily expenses, shared credit cards, documentation showing both spouses responsible for a car loan, a mortgage, or major bills, these all carry weight. If you keep finances almost completely separate, without a clear, believable explanation, that may raise red flags. Insurance is another overlooked but powerful category. Health insurance policies listing both spouses or listing one spouse as the other's dependent. Auto insurance covering both of you and possibly multiple vehicles. Renters or homeowners insurance with both names. Life insurance or retirement accounts where spouses name each other as beneficiaries. All of this says, we plan for the future together. If something happens to one of us, the other is protected. That's exactly what USCIS expects from serious marriages. What about letters from friends and family? Affidavits can help, but they are supporting os evidence only. They should never be the backbone of your case. USCIS officers have read thousands of generic statements like, I have known this couple for many years, and they are truly in love. When every letter looks and sounds the same, it loses credibility. Good affidavits come from people who have spent real time with you as a couple, who can give specific examples. Holidays spent together, trips, challenges you overcame, how you participate in each other's families. But even the best letters cannot replace documents that show your actual life together. Now let's talk about timing. Because the calendar is a silent trap for a lot of people. By law, you must file Form I-751 during the 90-day window, before your conditional green card expires. If your card expires, say, on December 1st, then your filing window opens around September 2nd and closes on December 1st. Filing too early can lead to rejection. Filing after the expiration date without a strong explanation is extremely risky. If you miss that window, USCIS can terminate your status and start the process of sending your case to immigration court. In some cases, if you have a very compelling reason for filing late, serious illness, natural disaster, something truly beyond your control, they may accept a late filing for good cause, but you never want to count on that. Once you file Form I-751 properly, USCIS will send you a receipt notice. Today, that notice also serves as an automatic extension of your conditional green card, currently up to 48 months beyond the expiration date printed on your card. That letter, plus your expired card, proves that you are still a lawful permanent resident while your case is pending. You need this for work, driver's license renewals, and travel. Losing it creates headaches you do not need. After that, USCIS may schedule you for biometrics, fingerprints, and a photo. Sometimes they reuse biometrics from an earlier case, but these days more and more people receive fresh biometrics appointments as part of updated security and fraud detection efforts. Ignoring a biometrics notice or missing the appointment without rescheduling is a common but serious mistake. At some point, many applicants receive a request for evidence, RFE. This is not a formality. An RFE means the officer isn't convinced, at least not yet, that you've provided enough proof. Maybe your photos are weak, your joint bills are limited, or your living situation is unconventional. When you get an RFE, how you respond can decide your future. Guessing, rushing, or sending whatever you can find in a few hours often leads to denial. You need to read every line of that request and respond seriously, with organized, high-quality evidence that directly addresses what they're asking for. If you're not sure how to respond, that's the time to consult a qualified immigration attorney, not to roll the dice alone. Some couples will be called in for an I-751 interview. Not everyone is interviewed. USCIS can waive interviews for strong, straightforward cases. But if you do get an interview notice, understand that this is not a friendly check-in. It's an opportunity for an officer to test your evidence in person. Both spouses are usually expected to attend. Officers may ask detailed questions about how you met, your proposal, your wedding, your daily routines, your work schedules, your home, your families, your arguments, and how you handle them. They may ask about who sleeps on which side of the bed, who pays which bill, what you did last weekend, who cooks, which relatives you've visited, or what color the walls are in your bedroom. They are not looking for movie-perfect answers. Real couples forget details or disagree sometimes. What they look for is overall consistency. Do your answers fit with each other, with your documents, and with the timeline in your file? Couples with genuine marriages can and do fail interviews when they are totally unprepared, extremely nervous, or treat the process casually. Preparing together, going over timelines, reviewing your documents, talking through your story can make a huge difference. Processing times for I-751 cases vary dramatically across service centers and change over time. Some cases are approved in under a year. Others take 18 months, 24 months or more. Long processing times do not automatically mean trouble. Sometimes they're just a symptom of backlog. But they do mean you need to plan your life, especially travel and job changes, around the reality that your status is under review for a long time. Now let's talk briefly about waivers. Because not every I-751 is filed jointly. Life is messy, marriages break down, people get divorced, some spouses are abused. In those situations, the law allows you to file I-751 without your spouse, using one of several waiver categories. You can file alone if the marriage was entered into in good faith, but the marriage ended in divorce or annulment. The marriage was entered into in good faith, but you were subjected to extreme cruelty or abuse by your US citizen or permanent resident spouse. The marriage was entered into in good faith, but your spouse died. Terminating your residence would result in extreme hardship. These waiver cases are more complicated and are scrutinized heavily, but they are absolutely winnable when they're prepared with strong evidence. The standard is still the same. You must prove the marriage was real when it began. If your I-751, joint or waiver, is denied, the consequences are severe. Your conditional status is terminated, and in most situations, USCIS will send your case to immigration court. You don't simply get to send in another I-751 and try again. At that point, an immigration judge has to decide whether you should be removed from the US or allowed to stay. That's why treating this process as just paperwork is so dangerous. This is a critical checkpoint in your immigration journey. There is one more strategic angle many people don't know about. In some situations, you can apply for US citizenship while your I-751 is still pending. If you've been a permanent resident for 3 years and you're still living in marital union with your US citizen spouse, you may be eligible to file Form N-400 as early as 2 years and 9 months after you became a resident. That's 3 years of permanent residence, not 3 years of marriage. When you do this, USCIS often schedules a combined interview. They review your I-751 and your N-400 together. If all goes well, you can be approved both for removal of conditions and for naturalization in one step. In other words, go directly from conditional green card to US citizen, skipping the 10-year card stage. But this is not a magic shortcut. If your marriage is unstable, if you're separated, or if there are major question marks in your case, filing for citizenship too early can complicate everything. Sometimes it's smarter to get the I-751 approved first before adding another application. So where does all of this leave you? If you have a conditional green card, your next steps are some of the most important of your entire immigration journey. Do not delay. Do not guess. And absolutely do not just copy what someone else did on the internet. Every marriage is different. Every file is different. USCIS notices everything. Here's what you should do now, calmly and deliberately. Check the expiration date on your card and mark the start of your 90-day filing window on a calendar. Start collecting strong, objective evidence of your life together. Joint tax transcripts, leases or mortgages, joint bank and credit accounts used for real transactions, shared bills, insurance policies, photos spread over time, and any documents showing children born to the marriage. If you've had separations, address them honestly. Gather evidence that explains them. Work contracts, school records, medical documents, travel itineraries, messages that show the relationship stayed active. Make sure you are using Form I-751, not I-90. Double-check the instructions and filing fee on the official USCIS website. If your relationship has ended or is abusive, talk with an experienced immigration attorney about filing a waiver rather than rushing into a weak joint filing or doing nothing out of fear. Here on Immigration Bulletin Hub, the goal is to help you understand these processes before they turn into emergencies. If this explanation made the I-751 process clearer or helped you see risks you hadn't considered, take a moment to like this video so that it reaches other conditional residents who might be quietly heading toward a deadline. Subscribe to Immigration Bulletin Hub and turn on notifications so you don't miss future updates about green cards, citizenship, travel rules, and other changes that can impact your status. Immigration rules change fast, and missing one key update can cost you years. If you have questions about your specific I-751 situation, joint filing versus waiver, time abroad, gaps in evidence, drop them in the comments. I can't give individual legal representation here, but your questions help shape which topics I cover next, so that this channel stays practical and relevant. Most couples who run into trouble with I-751 did not set out to do anything wrong. They trusted bad advice, misunderstood their own status, or underestimated how seriously USCIS takes this process. You don't have to be one of them. You've already done the hard part. You got the conditional green card. Now it's about finishing the job. Be thorough, be honest, be proactive, and don't let a preventable mistake decide your future. This is Immigration Bulletin Hub. Stay informed, stay organized, and I'll see you in the next update.